petition and appeal in the matter of FH Holding Moscow Limited and UniCredit Bank and another.
Yes,
My Lords. My Lords, I should start by saying there should be three further authorities on your
Yes.
Lordship's bench. Those were provided to my learned friend on Sunday. They relate to the points on the Russian judgment that I said I wanted to make briefly at the end, so I'll come to those if I may
Right.
at that point. To start with, yesterday my Lord Justice Popplewell asked about the requirement for a valuer's report pursuant to clause 9.2, so if I could respond to that first. That is, if I could ask your Lordships to turn it up, so it's SUP Bundle 1, page 157. And my Lord's question was whether clause 9.1.4 and 9.2 meant that if AO wanted to execute, they first had to get a valuation of all the properties. So, my Lord, the answer we say is no, because it's right, market value is determined during the foreclosure proceedings. Ms. Trasova refers to that in her first witness statement, which your Lordships would have seen. It's para 45D. And we say, as a matter of construction, the date in clause 9.2 is a backstop date to ensure that the valuation is no older than that. But that is all it is. So looking at clause 9.2, the market value is to be based on the acceptable valuer's report prepared up to, and then 3 months before the date when a court is petitioned to levy execution. So a report can be provided during the course of the proceedings rather than before.
So it's not a condition precedent
to
petitioning the court. It simply fixes the timing of the valuer's report.
Absolutely. And we understand that's also the position as a matter of Russian law. There's no requirement there. And just so that your Lordships have the reference in case you'd like to see it, the facility agreement does deal with valuations at clause 16. So that's at page 59 of this bundle. And it doesn't provide for quarterly valuations. It provides for annual valuations, but it does provide at 16.3.2 that the borrower, so FHM, is obliged promptly on demand to provide to the agent all information and documents required to conduct a valuation. And I was then going to address grounds 3 and 4 of FHM's appeal. I was proposing to do so briefly, subject to any issues your Lordships wish to raise. The points we rely on are the ones in our skeleton, paragraphs 44 to 52. The only point to emphasise is that we say the basis on which FHM says it has a claim against SPA remains entirely nebulous. As my Lord Justice Mayles observed yesterday, the only pleaded breach is a breach by AO, breach of contract is a breach by AO, and there's no breach of contract pleaded in the claim form, but it's not, breach of contract by SPA is not alleged or established in the evidence either. Now,
the way Mr. De Crist was describing the claim, although he didn't quite put it like this, sounded to me more like a claim for inducing breach of contract.
My Lord, I was just about to say one can see it might be open to try to bring a claim on that basis. But the first point here is that that isn't what's pleaded, nor we say what's evidenced, and it isn't what my learned friend said yesterday or what's in the papers. What's been set out so far is a claim for breach of contract, and that's the focus on the appeal. So FHM have emphasised the authorities, relied on the authorities on this point that say that if breach is shown, then an ASI will follow absent strong reason. And that's a principle that applies in the case of a breach of a arbitration agreement. So we do say at this point it's too late for FHM to try and identify and make out some different basis. And in terms of the evidence, there's been a lot of emphasis throughout, well, but at first instance and in this court, about the fact it's said that there's been no answer provided by the respondents to the points that are made in relation to SPA. But it's very important in that context that the claim that's being made against SPA hasn't been clearly spelt out, because it's impossible to answer an allegation if one doesn't know what it is. So far as it's said that SPA is a parent of AO, that's the position. But the speculative evidence or the conclusions that Mr. Greaves says he's drawn in his evidence don't, we say, come close to what would be needed to make out some kind of different claim, even if it was pleaded, but it isn't, and that isn't the basis on which it's been put. And we say it is too late for that to be advanced now. I was then going to move on to the CPR 62 point, unless there is anything.
This is your respondent's notice point.
My lord, yes. So, my lord, this argument is based on the wording of CPR 6.1 and of CPR 62.5. And as your lordships would have seen, we say that 62.5 makes different provision within the meaning of CPR 6.1 for the service out of the jurisdiction of an arbitration claim form. And then we rely on the wording of CPR 62.5. If I can ask your lordships to look at those provisions. At the back of the second authorities bundle. (62.5) is on page 629. So 62.51 provides that, subject to paragraph 2A, the court may give permission to serve an arbitration claim form out of the jurisdiction if, and then sets out the relevant requirements. And we say that the natural meaning of that is that there is no other basis on which the court may give permission to serve an arbitration claim form out of the jurisdiction. My learned friend makes a point that we are, in advancing this case, asking the court to read this provision as if it provides only if, and that is impermissible. We say that's wrong. The CPR usually provides in this way for setting out the circumstances in which the court may exercise a power in exactly these terms. So, for example, there are three familiar ways in which one can look at. CPR 13.31, dealing with default judgment. In any other case, the court may set aside or vary a judgment entered under Part 12 if A, real prospect of successfully defending the claim, or it appears to the court there's some other good reason. And the effect of that rule is that it is only if those conditions apply that the court will exercise that power. Similarly, CPR 19.22 for ordering a person to be added, and similarly 24.3 summary judgment, the court may give summary judgment against a claimant or defendant on the whole of a claim or issue if AB. So we say there's nothing surprising about that reading of 62.5.
Well, you've got it in 636 as well.
My lord, yes. Yes.
May serve a claim form out of the jurisdiction with permission or if any of the grounds set out in the
My
practice
lord,
regs apply.
my lord, yes. So nothing surprising we say about that approach to 62.5. And we say when one reads 62.5, it's clear that it's making different provision within the words of 6.1, so that the service out rules in CPR 6 simply don't apply. So for that reason, we say that the point that my learned friends make at paragraph 8 of their skeleton on this, if I can ask your lordships to look at that. This is the separate skeleton on this point, so that's at page 83 of the core bundle.
Is the effect of this submission that you can't get an ASI?
Well, my lord, it would affect the ability to serve out in the case of ASIs, and I'm going to come on to.
You can't get one, can you? If you want to serve out.
You can
Because
get
because
one.
an ASI is not doing any of the things enumerated in 62.5, is it?
You can do it if you're getting if the seat is in England and Wales.
Well, you're getting an order under section 44, is that?
No, you are getting sorry, my lord, it's 62.5 1C. It's some other remedy.
Oh, I see.
My lord, that was one of the points that Lord Mance decided in Comenagos because it wasn't considered to be clear. Because yes, it's not under section 44, but it's.
Yes, I see. Well, that you can only do that if the seat is within the jurisdiction.
My lord, yes. And section 2.4, which it goes on to refer to, that's one of those cases where the seat hasn't yet been determined. So that's the reference to that. So my lord, yes, it does have an impact on the ASI cases. I was going to come on to that in a moment if that's right.
So if you're right, this is a point that nobody spotted in Ruskin Alliance.
My lord, yes. Well, or nobody argued, yes. My lord, we do say it is flagged because it's the point that Lord Legate addresses in paragraphs 91 to 93 of the Ruskin decision, where he identifies what he calls an anomaly between 62 and CPR 62.5 and CPR 6 in the proper place requirement for a claim form served out under Part 6. So we actually rely on that. The fact that that was identified as an anomaly, we say supports our point here.
So the anomaly is in the rules. If the principles are as articulated in Ruskin, then there are cases in which it would be appropriate to grant an anti-suit injunction, where the seat was not in England, but the rules don't.
My lord, yes, and we say that's not surprising when one thinks about how the law's developed. Ruskin is expressly a development on the law for granting anti-suits where the seat is not in England and Wales, and obviously when the rules were drafted, that wasn't the position.
So is this then the position that you can get an ASI where the seat of the arbitration is outside the jurisdiction, provided that you can serve within the jurisdiction? Is that what it comes to?
My lord, yes. Yes. So, my lord, to address the points on the text first, and then if I may come back to the points about Ruskin, etc. The point that my learned friends make on the text at paragraph 8 of their skeleton is that Rule 630A states that this part, so that's part 4, the part of part 6 dealing with service out, this section contains rules about service out of the claim form and other documents out of the jurisdiction without distinguishing between particular types of claim forms. And then they say, therefore, that extends also to arbitration claim forms. Now, we say that's simply wrong because 6.1 provides that part 6 doesn't apply if a different part makes different provision, which we say 62.5 does, and therefore an arbitration claim form isn't within the language of CPR 6.30a. And we do say that if your lordships want to look at 630A, that's at page 601 of the bundle. We do say that's, although this isn't conclusive, that is certainly consistent with the language of 630A. So this section contains rules about service of the claim form and other documents out of the jurisdiction. We rely on the fact that CPR 62.53 expressly provides that certain parts of CPR 6 will apply to the service of an arbitration claim form. But those parts of Part 6 which are expressly applied to arbitration claim forms do not include 636, which is the rule that brings into play the Part 6 gateways. So we say that shows the Part 6 gateways don't apply because CPR 636 isn't said to apply to arbitration claim forms anywhere in CPR 62.5. The rules that are referred to in 62.5, my learned friends make this point, they are 634, 635 and 640 to 646. They are procedural requirements, as my learned friends say. They're important ones, but basically to do with the process of serving out, for example, forms that have to be filed, periods for response, methods for service, etc. So FHM's response to this point that we make is to say they're just procedural rules, so they're of a different type to 636 in the gateways, and that it's and the gateways wouldn't naturally fall into a group with these rules, and that they say that's not surprising because they say 62.53 isn't dealing with any gateway type issues. So they say that in broad terms, this point we make on the express inclusion of these particular provisions from CPR 6 missed the structural point that service out under 636 is a general rule that is supplemented by 62.5. So that's their overall case again. But, my lords, we say that argument can't be right. So this is the fundamental point they make, is that references to claim forms in Part 6 include arbitration claim forms. That's the way they say this works. Now, we say that can't be right because of these provisions of 62.53. Because if it was the case that a reference to a claim form in CPR 6 includes an arbitration claim form, starting, for example, with 630A, then there would be no need for this provision at 62.53 because these rules would all apply anyway.
If the appellants are right on this point, is there anything you can do under 62.5 which you couldn't have done under 636?
And anything they could have done when they were issuing the claim?
Yes, I mean, if the appellants are right on this point, what does 62.5 add to the ordinary grounds, so to speak, on which you can get the court's permission to serve out?
What we say the difference is between the two sets of provisions is that they look at service out through a totally different lens.
No, I follow that. I understand your position. I'm just trying to work
what
content the appellant's position gives to 62.5, which isn't already catered for CPR 6.
It would give the ability to serve on a party to an award that had its seat here, which otherwise had no connection with this country, I imagine.
my lord, it's all focused through the seat of the arbitration effectively, because also it's relevant looking at that first head that there's a reference to an arbitration award made within the jurisdiction, and your lordships can see at the top of page 629 the place where an award is treated as made is determined by section 53 of the Act. Now, what section 53 of the Act says is that an award is made where the seat is. It doesn't matter where it's actually made. The award is made by operation of the Act where the seat is. So it's all of this is very much focused on the seat. So it's a totally different lens to look through servicide, which we say is appropriate for international arbitration, as opposed to this court exercising its normal jurisdiction, starting with people within the jurisdiction.
B may apply where the seats are not in England if the arbitration agreement is governed. The arbitration
Yes,
agreement
yes,
is governed
my
by
lord, yes,
English law,
yes,
by express choice,
yes,
let's say.
Yes, my lord, absolutely. So
Royalty
yes,
under section 44.
yes. So it's all to do with whether the parties to the arbitration have agreed that there should be an English connection to the arbitration. And section 44 is there's an ability to serve out in the case of an order under section 44, but those are orders made in support of an existing arbitration which may be proceeding elsewhere. So again, it's not the court asserting any sort of additional jurisdiction which could be thought to undermine or contradict the jurisdiction of the tribunal. So we do say there are different comity concerns when one's considering the court's role in support of or in relation to arbitration proceedings, and that's why these rules are drafted differently, and there's a different set of requirements to those which apply under Part 6. So, my lord, this is the main point that I was addressing. The main point on the text of the rules that's made by my learned friends, and that's paragraphs 8 and then 10 to 11 of the skeleton. So we say that that's wrong, and that this reference to specific rules in Part 6 as applying shows why a reference to claim forms in Part 6 does not include an arbitration claim form. And so that demonstrates that's more than an inconsistency. I mean, the 2 points that my learned friends make here, paragraph 8 and then paragraphs 10 and 11, they can't both be right, but it's more than that. It's just an inconsistency in their arguments. It demonstrates that their approach to construction is wrong because of this point about whether whether 62.5 is an add-on to the CPR 6 jurisdiction when one's looking at an arbitration claim form, or whether 62.5 is the available regime. Looking at the other points that FHM make, at paragraph 6, it said that CPR 62.5 doesn't make different provision because it's not inconsistent, and we say, well, that's not right for the reasons I've just addressed. Para 7 is a point on policy, and I'll come back to that in a moment. Paragraph 8 is the point I've just addressed, and then paragraph 9 is the point which we are said that we're somehow impermissibly asking the court to read 62.5.1 as if it's saying the court could give permission to serve out only if, and I've addressed that already to show your lordships why we say that is the natural reading of the clause and consistent with other rules, including, as my Lord Justice Lewison's pointed out, in Part 6 itself. And in Para 12, which is the last point of their skeleton on this, this is the reference to what Professor Briggs says in his book. But we say really this doesn't help them, because it's clear from the text that's set out that what Professor Briggs is doing is describing the position as it's currently understood. He's not expressing a view on the construction of the rules or whether this is the correct situation. So it's a descriptive paragraph, and we say therefore doesn't add anything to the situation. So moving to the policy points, as it were, the point that's made by FHM is the point at paragraph 7. And what is said there is that it would be absurd if the court didn't have jurisdiction to grant an ASI in respect of a foreign-seated arbitration, but could grant other interim relief in respect of that foreign-seated arbitration under Section 44. So, and they say there's no reason, there would be no substantial good reason for that distinction. We say that's wrong. First of all, there is a substantial difference between those two types of relief. As I've said already, Section 44 relief is very much relief in support of another jurisdiction going on. And there are not the same comity concerns in particular which could arise with this court ordering anti-suit relief.
Can you have an interim anti-suit injunction under Section 44?
My Lord, one can do, yes. It's not in a position to give evidence. That they may often be less useful because of the treatment of an order from this court, for example, as compared to an order made by a tribunal. So that was one of the issues that was considered in Ruschem, the impact of any order that might be made by the tribunal. Sorry. Sorry, I think I may have answered your Lordship's question incorrectly. I think it's paragraph 90, my Lords of Ruschem discusses this.
We're going to Ruschem.
My Lord, yes. Page 539. Sorry, yes, I jumped horses halfway through your Lordship's question. The point I jumped to was the point about the power of a tribunal to grant an injunction, which is obviously different.
Yes,
and that's
really asking about that.
no, my Lord, sorry, that's yes, and that's the point that's discussed in terms of the lack of coercive effect, etc. But yes, my Lord, so this is the discussion in Ruschem by reference to Kamenogorsk, where it said that, of course, what Kamenogorsk does is say that the court's power is the Section 37 power. Although that is making the point that that's when the proceedings aren't on foot.
It looks from that paragraph as if you could have
Yes, my Lord,
an
I
interim
was going to say yes,
by a court
as long
under
as it's,
Section
yes,
44,
my
so
Lord,
long as
the proceedings are on foot, yes, yes, yes.
So if that's right, then doesn't that highlight the anomaly which the appellants draw attention to in paragraph 7? You can have interim relief, but not final relief.
Well, my lord, it is different if arbitration proceedings are ongoing, and the parties make an application in accordance with the requirements of section 44 to injunct proceedings brought in a court separate from those tribunal proceedings, then it's very much the case that the tribunal is already constituted and the interim relief is very clearly in support, if one might put it that way, of a set of existing arbitration proceedings. It is rather different if one is seeking the type of anti-suit relief that occurs here, where to do with the negative obligation, so without any obligation to start arbitration proceedings, no arbitration proceedings are on foot. And the English court is deciding in those circumstances that it will injunct proceedings abroad on the basis of an arbitration agreement where there aren't yet proceedings ongoing.
Well, I follow that the appellants might not have been able to get to section 44 injunction in this case,
Yes.
because there were no
Yes.
proceedings, and section 44 has hurdles for a claimant to overcome, such
Yes.
as either getting the permission of the tribunal or demonstrating urgency
Yes.
and so forth.
Yes.
But nevertheless, the general point seems still to apply.
Well,
That seems a bit odd if you could get an interim injunction under section 44, because you would then qualify under CPR 62, but you couldn't get a final one because that is granted under the Senior Courts Act.
well, my lord, in the situation where the arbitration proceedings are already on foot, the starting point is normally that one needs permission from the tribunal. So if one starts from the position that the parties have agreed to that form of proceedings, and then there is the additional requirement for a section 44 application of requiring consent other than in a case of urgency, and then in the case of urgency it has to be shown that it really is urgent. There's a requirement to bring it back to the tribunal as soon as possible, etc. That does involve a level of regard to the jurisdiction of the arbitral tribunal that isn't there in the case of an application such as this to enforce simply the negative obligation. Now, obviously, that's partly simply a reflection of the fact that there aren't proceedings on foot, but it does give rise to a significant difference nonetheless in terms of the comity issues, because the parties haven't in a case such as this agreed by signing up to the arbitration agreement in this positive situation to anything to do with the English court's jurisdiction, and there is nothing else to mediate in this situation, as it were, or nothing else to come into play in respect of the English court's jurisdiction. Whereas in a section 44 application, the parties have signed up to whatever the relevant arbitration agreement is, and proceedings are underway and will proceed in front of that tribunal, which is then in a position to deal with the results of, including whether the results of the section 44 application, whether that relief should be continued. So an ASI in this type of situation is without that check, as it were, or that level in this context of a form of supervision from the tribunal. So my lord, we do say there is a difference between section 44 relief and section 37 ASI relief. And we say there is every reason to think that the draftsman of the rules intended there to be a distinction between those two types of relief, because as I was submitting earlier, what Ruschem shows is that the ability to grant an ASI was previously regarded as part of the supervisory jurisdiction of the court of the seat. So in Ruschem, that's paragraph 96 at page 541. And actually, we start slightly earlier in the middle of paragraph 95. Lord Leggett refers to Enker and refers to what he and Lord Hamblin said in that case. And at paragraph 174, so this is at B on page 541, describe the grant of such injunctions as a well-established and well-recognised feature of the supervisory and supporting jurisdiction of the English courts. In both these cases, however, the parties had chosen England as the seat, and in neither case was it necessary to delve into the precise basis of the power to grant anti-suit injunctions or its relationship with either the supervisory or supporting jurisdiction of the court. So then he goes on in 96, and at the end, as I think your lordship saw yesterday, at the end of this paragraph, however, it is in fact clear on analysis that the power to grant such relief is not an aspect of either the supervisory or the supporting jurisdiction of the English court. So that's a change in the way in which the ASI jurisdiction was understood that was made in Ruschem. So certainly at the time the rules were drafted, the ability to grant a section 37 ASI was tied to the supervisory or supporting jurisdiction of the court in a way which it's now been said it isn't.
And is the rationale for that it's nothing to do with supervising or supporting an arbitration? An anti-suit injunction is simply enforcing a contract like any other contract, i.e. the negative promise.
My lord, yes, I mean there are if one takes the view that one wants to enable this type of anti-suit to be granted, so it's one way of looking at that question is that there are two ways of addressing, if presumed for this purpose I'm right on this submission, there are two ways of addressing the problem. One either says it's all to do with a contract, and so it's really to do with, because it's section 37, not section 44, it's all to do with part 6. In that case, it would be neat. It should be clear that all cases involving anti-suits other than section 44 anti-suits would be part 6. Or one would say, well, it's now been recognised that the jurisdiction to grant an anti-suit is not tied to or related to the supervisory or supporting jurisdiction, but it's still very much to do with the approach these courts take to supporting and upholding arbitration agreements specifically, and that those are treated differently to other contracts, in which case one might say that the appropriate course would be that there needs to be a change to CPR 62.5.
Well, what I was wondering was if it is nothing to do with supervising or supporting an arbitration,
Yes.
but simply enforcing a contract, a contractual promise, why does it have to be an arbitration claim form? Why can't you just issue an ordinary claim form? I know that the claim form in this case has the word arbitration on it.
Yes.
Does it need to?
That's in part 62, my lord. So yes, because one might say yes. So if we look at 62, that's at starts on page 625. And there's a definition in 62.2, which is on page 627.
You're 62.2D, aren't you?
My lord, yes. Any other application affecting arbitration proceedings, whether started or not, or an arbitration agreement.
So then you say 62.31 tells you must
My
issue
lord,
an
yes.
arbitration claim.
My lord, yes. And my lords, your lordships probably have it in mind, but the passage in which Lord Legate considered the anomaly, as he identified it, that's at 91 to 93 of Ruschem, so that's 539 to 540.
So I just got one other question, if I may.
Sorry, yes.
62.4 tells you what the arbitration claim form must state. And that includes specifying under which section of the 1996 Act the claim is made. If the claim is a claim not under the 1996 Act, but section 37 ASI,
Yes.
how do you comply with that?
My lord, I think if it's not under any section, that's simply not, it's not made under a section, so that's simply not.
So even though it says you must specify, what it means is which section of the 1966 Act, if any.
If any. Well, my lord, yeah, I think that's the way it's been treated.
It B is details of any arbitration award challenge, and it might not be an award.
Yeah, except that that has the word any.
Any.
Yes, it is. Under C, there might not be any statutory requirements.
But D seems to be imperative.
My lord, sorry, I was just going to show your lordships the Ruschem 91 to 93 passage. And in particular, as your lordships can see, Lord Legate identified the difference, which,
Which paragraph?
sorry, 91 to 93. So at the end
Yes.
of 91, which is on top of page 540, Lord Legate, so at the bottom of 539, Lord Legate says that there's no requirement in 62.5 equivalent to the proper place requirement in CPR 637.3. The point that permission to serve out will not be given unless the court is satisfied that England and Wales is the proper place. So he says that that applies for CPR 6. It's not included in 62.5. And then at 92, he says, I cannot discern any good reason for allowing service out of the jurisdiction on any defendant, subject to the court's general discretion, of a claim form seeking an order under section 44 for interim relief in relation to an arbitration with a foreign seat, and yet imposing an additional test where the claim is for an injunction to restrain breach of the arbitration agreement by a defendant over whom the English court has personal jurisdiction under the contract gateway in Part 6, 3.16c. This apparent anomaly in the procedural rules need not and should not, however, prevent the court from adopting a principled approach to the exercise of jurisdiction. And he says, in his opinion, the proper principle to apply in both cases is that expressed in section 2.3 of the Act.
Just remind me, what does section 2.3 say?
Sorry, it's set out above. It's
Basically says what's in the next sentence of your list.
money, yes. Yes, it's not interfering unless it's the, sorry,
Where you have a foreign seat.
my lord, yes, it is. Sorry, para 89, thank you. Paragraph 89, so just on the previous page, so it's the first quoted passage in paragraph 89.
Sorry, maybe we're in the middle of 92.
Sorry, thank you. So 2.3 of the Act, service out of the jurisdiction should in principle be permitted unless, in the opinion of the court, the fact that the seat of the arbitration is or is likely to be outside England and Wales makes it inappropriate on the facts of the case to exercise the court's jurisdiction to grant relief aimed at enforcing the arbitration agreement or supporting the arbitral process. This test should be applied consistently with the principle discussed above, that a strong reason needs to be shown as to why in the particular circumstances the court ought not to exercise its jurisdiction to restrain a breach of the parties' contractual bargain. So that's the Donoghue and Armco, etc. approach to upholding an arbitration agreement absent strong reason. And then 93, I do not consider that the wording of CPR 637.3, which requires the court to be satisfied that England and Wales is the proper place in which to bring the claim, precludes this approach. Those words are capable of being read in a case of this kind against the background of a presumption which treats the courts of England and Wales as the proper place in which to bring the claim for an anti-suit injunction, unless the fact that the arbitration has a foreign seat makes it inappropriate to do so. So, my lords, we do rely on the fact it's identified as an anomaly, and my lord, and we say that supports our submission that they are in fact separate regimes, and that the only regime intended to apply to arbitration claim forms is CPR 62.5. And that the process set out here reflects an attempt to apply, or a way of applying the considerations from 62.5, which apply to arbitration claim forms, to a CPR 6 claim. But it really, we say, shows that it's meant to be within 62.5, if at all, that permission is given for an arbitration claim form. My lords, just to go back to the question that my Lord Justice Mayer's asked me about the section 44, section 37 type of injunctions. The passages in Kamenogorsk, so particularly paragraph 46 and 48, are helpful. There was obviously an argument being made in Kamenogorsk that section 44 was intended to exclude the court's power under section 37. That was one of the points that was argued in that case. And in paragraph 48, so this is on page 322 of the first authorities bundle. Show you the whole paragraph. Claimant says the better view, in my opinion, is that the reference in section 44.2e to the granting of an interim injunction was not intended either to exclude the court's general power to act under section 37 of the 1981 Act.
Which paragraph?
Sorry, 48, my lord. On page 322 of the bundle. So
Yes.
44.2e was not intended either to exclude the court's general power to act under section 37 of the 1981 Act in circumstances outside the scope of section 44 of the 1996 Act, or to duplicate part of the general power contained in section 37 of the 1981 Act. Where an injunction is sought to restrain foreign proceedings in breach of an arbitration agreement, whether on an interim or a final basis, and whether at a time when arbitral proceedings are or are not on foot or proposed, the source of the power to grant such an injunction is to be found not in section 44 but in section 37. Such an injunction is not for the purposes of and in relation to arbitral proceedings, but for the purposes of and in relation to the negative promise contained in the arbitration agreement not to bring foreign proceedings, which applies and is enforceable regardless of whether or not arbitral proceedings are on foot.
So it's just you can't have an interim anti-suit injunction under section 44, but you can have other forms of interim relief under section 44 where you've got a foreign suit. Does that how we reconcile what's said there with what Levitt was saying in UniCredit?
My lord, yes, I think so. My lord, yes, and that's supported by the second half of paragraph 46 on the previous page. So Lord Mance is considering 44.2 in this paragraph. And here's the point that is, so starting in the middle of that paragraph, no power to grant a final injunction even after an award. There is authority that section 44.3 can include orders urgently required, pending a proposed arbitration to preserve or enforce parties' substantive rights. And then between F and G, orders restraining the actual or threatened breach of the negative aspect of an arbitration agreement may be required both where no arbitration proceedings are on foot or proposed and where the case is not one of urgency. They enforce the negative right not to be vexed by foreign proceedings. This is a right of a different character, both to the procedural rights with which section 44 is mainly at least concerned and to the substantive rights to which the Hiscock and Settlone cases hold that it extends.
But before you
My
what
lord,
about
sir.
paragraph 51? Is that a decision binding on us that CPR 6 does apply?
My lord, we've it wasn't necessary in this case for that decision to be made. because there was jurisdiction under 62.5C is the provision there, which would survive. But my lord, we say for that reason it's not strictly speaking binding. But my lord, we recognise it's been applied frequently and followed. This point wasn't argued in that case. This point about the exclusive construction to the rules wasn't argued.
In 51, as I read it, Lord Manson simply recording the fact that leave was obtained both under CPR, the practice direction CPR 6B, and also under 62.5. And what he is saying is there could have been another ground under the practice direction.
Under 6, yes, my lord. And so the one that survives is 62.51C, I think. But yes, he's observing that it seems to him that it could also have been sought under this other, under the in respect of a contract provision of 6. But as we say, so it wasn't argued, it wasn't necessary, but that approach has been applied repeatedly. And your lordships would have seen we refer in our skeleton argument. So, for example, the only other case we've been able to find in which this point was argued was the decision in front of Mr. Justice Tier, where reference was made to that part of Lord Mance's decision, and Mr. Justice Tier said he wasn't going to disagree with that.
Sorry, that's Mr. Justice Tier in Roscoe Alliance, is it?
It's the case we refer to in our skeleton argument. Ship owners' mutual protection and indemnity, which is in the authorities bundle. It's 15, thank you. Tab 15, so it's authorities bundle 2, tab 15. So this is a first instance decision. The case did go to appeal and the point wasn't pursued on appeal. So the relevant passage, my lord, is on page 410 of the bundle. And at the top of the page, your lordships can see the argument. Mr. Carrier submitted that the club is seeking to enforce the London arbitration agreement contained in the club cover. Mr. Lewis made 3 submissions. First, CPR 6, 3.16C doesn't permit service of an arbitration claim form because 62.5 is an exclusive code. And then that's the point that Mr. Justice Tier considers in 41 and 42. And he refers to the wording of CPR 6.1. And then in paragraph 42 says the difficulty is that this is inconsistent with Kamenogorsk.
Thank you.
So, my lord, we say that the fact the 62.51 regime is, as we say, an entire regime is supported by the fact that a comparison of the relevant factors for service out under 3.16 are different, and as I said, it's looking at the issue of service out through a completely different lens if one looks at those factors as opposed to the 62.5 factors. So 3.16 is the contract was made within the jurisdiction, was made by or through an agent trading or residing in the jurisdiction or governed by English law, and that's then compared to 62.5, which your lordships have seen. So challenge to or appeal of an award made in this jurisdiction, and as you say, it is relevant that when 62.5 talks about made within the jurisdiction, it said that's as defined as provided by section 53 of the Act, and 53 of the Act says doesn't actually mean made within the jurisdiction. It says if it's an award where the seat is England, Wales, or Northern Ireland, regardless of where it was signed, dispatched, or delivered. So it is quite a contrast between the provisions for 3.16 and the service out gateway. And then the other provisions in 62.5, as your lordships have seen, are an order under section 44, or the one that we're concerned with here, which is some other remedy or requires a question to be decided, affecting an arbitration. That comparison does provide another, we'd say, relevant example. If your lordships uphold the judge's decision on the gateway concerning in respect of a contract, then the effect is that the fact that the governing law of the matrix contract is English law isn't enough for service out of an arbitration claim form under Part 6. One could think about a case which was identical to this one, save where the contract had been made in this jurisdiction, because that's one of the other gateways under CPR, under the 3.16. So we could have an arbitration agreement providing for Vienna arbitration and therefore governed by foreign law, but made in this jurisdiction. And if service out is permitted under CPR 6, then it could be said that that gateway provides a basis for service out. And we would say that would be a surprising result if in a case, if on the facts of this case, your lordships agree that the judge was right to say that the fact the matrix contract was governed by English law isn't enough. And my lord, so one further point I should have made on the approach Lord Legate takes in those paragraphs 91 to 93 of Ruskin, where he's dealing with what he calls the anomaly. So he finds a way of making sense of the proper place test in a case such as this. But we say that he recognises that there's an anomaly, and really what that passage shows, we respectfully submit, is that test isn't appropriate for arbitration claim forms. It's an attempt to use the wrong rule to apply to get service out for an arbitration claim form, and that's why one gets into that slightly strained exercise of construction.
Your point, I think, is that by agreeing to an arbitration agreement with England and Wales as the seat, the parties have decided that England and Wales is the proper place.
Yes, well, my lord, yes, that's the rationale behind some of, yes, one part of 62.5, yes.
It's the rationale of the whole of it in the sense that you don't have the discretionary element
Well,
if you're within 62.5.
Yes. And my lord, we recognise that the decided cases are obviously important, and I identify the situations which need to be adequately addressed, but ultimately, my lords, we say that the rules say what they say, and if they don't provide appropriately for any change in the law in particular, which does seem to have occurred in this context, then the appropriate response is for consideration to be given to whether changes need to be made to the rules, rather than for the structure that's been provided for to be distorted by having to make rules do a job which they weren't intended to do, which we do say is the position here. My lords, unless there was anything else that I could respond to on that. I was going to just make two very quick points on the Russian judgment,
Yes.
if I may. So, my lords, these are points that don't arise unless your lordships are with FHM on their appeal and are considering whether to grant an anti-suit. So, and the points are that there's now been a Russian judgment, so that's a relevant change to the situation that your lordships would be considering in that situation. Your lordships have seen the judgment and the letter. So just as a reminder, the FHM's jurisdiction challenge was dismissed. The Russian court found that an offensive default had occurred and that AO had the right to foreclose, but it was said that AO was not entitled to foreclose without prior approval from either the Government Commission or Central Bank of Russia, and therefore dismissed our claim. And your lordships have seen that any appeal has to be made within a month. So AO needs to appeal on that issue of whether approval is required if that decision is not to come into force and thereafter be binding. Now, it wasn't entirely clear to us what FHM's position was on whether the anti-suit they seek would prohibit us from filing that appeal. My learned friend made clear, and we actually asked about that on Sunday, my learned friend made clear yesterday that they do say that the anti-suit would stop AO pursuing that appeal. If I can just ask your lordships to look at that order, because that shows the point. It's in the supplemental bundle at 603, so it may also be in the core, in which case that may be easier. Next, supplemental bundle.
Sorry, what is it we're looking for?
Sorry, the draft order, the draft anti-suit order. I have 603 of supplemental bundle 2. And your lordships can see on page 604, so the second page of this, there is a definition of the disputes which reflects what you've heard in submissions. So whether an event of default has occurred and the amount of any debt due. And it's by reference consistent with my learned friend's case. It's consistent with those disputes that the anti-suit is drafted. So one can see it.
Yeah.
1.1 that it stops AO from pursuing, etc., any claim in the Moscow proceedings relating to the disputes. So one can see there might be some room for confusion. I'm certainly not saying that AO would regard this order as leaving it free to pursue the proceedings without the issue being clarified, but it's not entirely clear, given that the point that AO would want to pursue an appeal is not the disputes. It's this separate point about whether approval is required from the Central Bank of Russia or the government authority. So it might be said that it's given the nature of the disputes and the basis for the anti-suit relief sought by my learned friend, that because we're now at this point simply trying to pursue that issue, that isn't something that should be caught by any anti-suit order your lordships might consider making. But if that were right, there'd then be an issue about any appeal FHM might want to bring from the decision that's been given in Russia. Because if there were to be an appeal by FHM, it obviously can't be right that AO would be prohibited from participating in any appeal. So we would say that even if there were an attempt to somehow carve out and deal with this problem by permitting AO to pursue the appeal it would want to appeal on the separate issue, there'd then be all kinds of confusion about the situation in the proceedings more generally. And so where that leaves us is that on any view we submit AO shouldn't be prohibited from pursuing its appeal on this issue of approval, because that's not something to do with the negative obligation in the arbitration agreement, because that isn't an issue within the scope of those disputes. And
a successful appeal would have the result of giving effect to the decision of the first instance court that there had been a default.
my lord, yes, it would. But my lord, I was going.
So if they otherwise have a valid claim for an anti-suit injunction to stop you litigating the disputed issues in the Moscow court, why shouldn't they be entitled to stop your appeal, the object of which is to do precisely that?
Well, my lord, it would leave us we would submit in an even worse position, because if one thinks about the point of the anti-suit sought as being that this becomes rather artificial. I was going to come on to make a point about lapse of time, etc. But if one posits a situation in which the reason for the anti-suit is that we're meant to pursue that dispute, if at all, in the tribunal, in the VIAC tribunal, if we did that and succeeded, then if we hadn't appealed this Russian judgment, we would be stuck with the result of the Russian judgment being as establishing that unless we had prior approval, unless we have approval, we can't foreclose.
But the Russian judgment hasn't said you can never foreclose, has it? In effect, it leaves it open for you to come back and say, well, we've got the bank's approval now.
Yes, it is possible to do it that way. There is then a limitation issue, which becomes relevant. So your lordships may have seen that Ms. Trasova gives evidence that the reason why AO originally issued these proceedings was because there's a 3-year limitation period that's beginning to cut into the relevant period. So that's paragraph 25A of her witness statement. There's disagreement between the parties as to when the period actually kicks in, but there is a limitation issue. So there is if the answer is that AO has to go back to the beginning again and get approval before it can do anything, then that does particularly prejudice its position. And my lord, the point we make at that stage is to say that to the extent this has all got very difficult and there would be problems with an order as a result of the Russian judgment having now been given, which we do say gives rise to particular issues of comity, because the Russian court has considered these issues, spent the time on it, issued the judgment, as your lordships have seen. That is something that weighs against the granting of an injunction. We've handed up the Donoghue and Armco decision, which is the authority for strong reason, being a reason to refuse anti-suit relief, even if there is a breach of an arbitration agreement or a jurisdiction clause. And we would say that there is now in this situation that kind of strong reason. And we've also handed up Ecobank and Tano, which is the Court of Appeal's consideration of delay, and in particular the effect it has on comity concerns when a foreign court has given consideration to the issues.
The premise for the submissions you're now making is that the appellants are right to say that what you did in Russia was a breach of contract.
Yes.
And of course you say that's not the right premise.
Yes.
But
Yes.
On that assumption, there was in fact plenty of time, and there may still be plenty of time for you to get the award from the Vienna Tribunal if you do that. So why should, if the fact that you got yourself into a mess in Russia is the result of your breach of contract, isn't that your problem?
Well, no, my lord, not entirely. And we do rely on Ecobank and Tano for that. Just so your lordships can see the chronology, there's a chronology in the core bundle, and it is relevant to this point. So the chronology is prepared by FHM. It's at tab 8, page 85. And we say there are two particular relevant periods of delay by FHM. So your lordships can see that the proceedings were issued in Moscow on the 21st of March 2025. And then there were three Moscow hearings, 28th of April, 28th of May and 9th of July, before on the 6th of August, FHM issued this claim. So there's some relevant delay there. And then the second relevant
Why is that a delay? That's FHM issuing a jurisdictional challenge, which on the hypothesis we're discussing
Yes.
ought to have succeeded.
Well, my lord, yes, but there is authority that it's it's a point made in Ecobank that it's not necessarily the right approach for a party to try and pursue a jurisdiction challenge in the foreign jurisdiction, wait for that to be refused, and then come and seek relief from the English court. It's difficult for litigants, but there is a relevant period of delay, we say, when these Russian proceedings were ongoing, particularly when Russia is a jurisdiction in which courts may say that they are, at various stages, that they are going to proceed despite applications or agreed positions by the parties that they would like an adjournment, which is what happened here, ultimately. So that there was that period of delay from March to August before FHM issued this claim form. And then we also say there was some delay between the hand-down of judgment by Mr. Justice Henshaw on the 25th of November and then the permission to appeal application, which wasn't made until mid-January, in circumstances where this case was obviously urgent by then. My learned friend sought expedition. I should recognise that there was delay in the consequentials hearing I think significantly as a result of a conflict and professional unavailability on my part. But if it was urgent, then hand-down hearings can be listed more urgently. There are ways around that, time of day, different people, etc. But it is quite a significant delay to in a case where it's being said it's urgent. And if the result of the overall timing has been to allow the Russian court to spend time and decide the matters at issue, then that gives rise to particular comity concerns, which we say are exacerbated by the delay, and we would say that would be further reason not to grant the anti-suit relief that's sought. Those are the submissions for the respondents.
Thank you very much. Mr. De Cruz, do you wish to reply?
I do, Your Lord. Yes, thank you. I'll start off, if I may, with dealing in reply to some points my learned friend raised yesterday afternoon, and I'll come to points made this morning. So, addressing first ground one. First point I'm going to reply to is UniCredit's argument that its interpretation of the agreements, both agreements, including clause 9 of the mortgage agreement, is more logical and commercially more sensible, because it said that it results in the dispute being resolved in one forum and to avoid fragmentation. That might have been a legitimate argument if the position of UniCredit had been argued and successfully established that clause 21 of the mortgage agreement has the effect of ousting the arbitration agreement and the jurisdiction of the VIAC tribunal in relation to the occurrence of an event of default. But that is not UniCredit's position. It's never been UniCredit's position, and indeed it wasn't the ruling of Mr. Justice Henshaw either, see paragraph 55 of his judgment. This case has always proceeded, and this appeal has always proceeded, on the basis of UniCredit's argument, Mr. Justice Henshaw's finding, that the effect of those two dispute resolution clauses are overlapping. So that it has been recognised, it's not been disputed, Fashion House is entitled, still entitled indeed, to pursue a VIAC arbitration to determine whether or not an occurrence of an event of default has arisen, alongside and notwithstanding enforcement proceedings in Moscow. And my Lords, Lord Justices Males and Popplewell yesterday identified some immediate practical reasons why that might occur. Lord Justice Males referred to the security being insufficient to pay off the debt in the Moscow proceedings, which would, which in that scenario may well require a VIAC award for further enforcement purposes. And Lord Justice Popplewell referred to, and this is our position, in any event, UniCredit wanting this English law issue as to whether or not there's been an occurrence of an event of default to be determined by their chosen method of dispute resolution under the arbitration agreement, namely a VIAC tribunal, for the very obvious reason that they have more confidence in the VIAC tribunal, both applying English law and applying it correctly. And we know that the Russian court didn't apply English law at all. And we say, therefore, there's always the possibility on UniCredit's case, indeed ongoing possibility on UniCredit's case, of overlapping judgments, conflicting judgments, etc. We also say objectively the parties must have identified the VIAC tribunal as a preference to dealing with issues relating to an event of default when they entered into the facilities agreement. Because if they didn't, if they took any other view, they would have provided, instead of the arbitration agreement at clause 42, a dispute resolution clause which sent everything, particularly in event of default, to the Moscow courts. They would have aligned, in fact, the dispute resolution mechanism in the facilities agreement with clause 21. The fact that
I don't understand that. They wouldn't have sent everything to the Moscow court. The Moscow court's only concerned with enforcing the security.
yes,
So if some other dispute arose in which SPA wanted a personal award against FHM, not enforcing the security, there'd be no reason at all to send that to Moscow.
no, the point I'm addressing is what, objectively speaking, the parties' intentions must have been at the time they entered into the facilities agreement as to how a dispute about an event of default would be determined. And we say, because an event of default clearly arises primarily under the facilities agreement, the fact that is then subject to a VIAC tribunal arbitration, a VIAC arbitration requirement under the arbitration agreement, is reflective of the party's intention that, amongst other things, that issue of an event of default would go to a VIAC tribunal, as opposed to the Moscow court under the mortgage agreement that was entered into at exactly the same time as the facilities agreement. So we said that is the proper logical inference to be drawn by these two different dispute resolution clauses. So, contrary to UniCredit's submissions, its case does involve overlapping a potential of two decisions on the same issue as to an event of default, with all the chaos, commercial chaos that entails, as set out in paragraph 47 of our skeleton, and which I outlined in opening submissions yesterday.
Do you include within that, the right that FHM would have to go to the VIAC arbitration and seek a declaration that
Yes.
that hadn't been? That's not what in fact has happened in this case.
Not to date, no. But that is not to say,
We're on now.
well, we are, and FHM has been, although we're looking at this objectively at the time of the facilities
I
agreement.
understand you say as a matter of construction.
Absolutely, that's
That
what
is a
this
realistic
is about.
possibility that would give rise to fragmentation.
Exactly.
But is there some reason you haven't done it that casts doubt on whether it would be a realistic possibility? Is there any evidence about why you haven't done it?
There isn't specific evidence as to why we haven't done it, simply because the issue hasn't been raised to date. But what I would ask your lordship to bear in mind is that FHM has been firefighting what's been taking place in Moscow, and it's a question of focusing on the immediate threat. But that isn't a relevant point, as your lordship has picked up. We are here to identify what must have been in the parties' minds at the time they entered into the contract. So this sort of scenario does not shed light on that.
Well, I was just picking up that you lit upon the two examples that came from the bench as to circumstances in which an AO might have wanted to go to the VIAC tribunal. The more obvious fragmentation point would be FHM going to the tribunal, and that wasn't amongst the things you included in your possibilities, but you do include it.
I certainly do. Yes, there may well have been an objective scenario at the time of the agreements for FHM to go to a VIAC tribunal in order to resolve an allegation that there had been an event of default.
Out of interest, does it cost anything to start an arbitration in the Vienna International Arbitration Centre?
I will be giving evidence on a point I have no knowledge of. So,
Not do that.
so I'm afraid I can't help your lordship on that. If it's interests your lordship, we can make some inquiries.
No, it probably doesn't matter.
I take it your lordship is referring to the cost of instituting the
Well, it's just
proceedings,
as-
not
just as-
of course legal costs.
Just as with the ICC or I think the LCIA, you have to put up some money when you start an arbitration.
I imagine that will be the case, but I don't know the details. Lord, that's my first point of reply. My second point of reply was the argument that AO's case does not involve granting it a unilateral right to determine whether or not there has been an occurrence of an event of default. And I think there might have been a misunderstanding about how we put that argument. On AO's case, it is entitled to commence enforcement proceedings and to trigger the gateway under clause 9.1.1 on the basis of its subjective assessment that there has been an occurrence of an event of default, even if that assessment proves to be flawed ultimately. So that itself means, my lord, and this is the way we put our case, AO's position does involve granting it a unilateral right to determine whether or not there has been an occurrence of an event of default for the purpose of establishing the 9.1.1 gateway, which is a critical point.
Well, it gives it the unilateral right to start proceedings.
Yes, and with that, we saw yesterday from 9.1.1, the terms of 9.1.1, what that involves is an occurrence of an event of default, which by starting it without having to go to a VIAC tribunal means giving AO the right to say, yes, in our view, subjective view, that has occurred.
But that's what happens when people bring cases in court. They think they've got a claim. The court
Yes.
may accept that or it may not.
Yes. So all I'm saying is you have a gateway that is established in clause 9.1.1, and the effect of AO's construction of the agreement, particularly
Is that they can start proceedings when they think there's been an event of default.
Yes.
I don't see anything
So-
particularly surprising about that.
That involves AO. All I'm saying is this is our argument, and it was disputed, but it does involve AO in a gateway sense, determining unilaterally that there has been an occurrence of an event of default.
No, it involves them asking the Moscow court to decide that that's the position.
Well, with respect, we disagree with that because there has to be an occurrence of default in order to establish the gateway, in order to justify the bringing of proceedings itself. So on their analysis, they can decide that point by starting the proceedings in Moscow without having to get any other sanction or any other finding specifically from
But how does that differ from anything? You have started this application because you have unilaterally taken the view that AO and SPA are in breach of the arbitration agreement. That was your decision. The court has decided against you. But there was no, of course you allege that your opponent has done something wrong. That's the nature of legal proceedings.
What we're talking about here is a contractual gateway and how that contractual gateway is proven and established. And my argument
Well, I know that. I know what the argument is.
My argument is that their case, it entitles them to determine unilaterally that that gateway has been satisfied without anyone gainsaying. That can't be right. Now, the next point I have, my lord, is in relation to Sebastian Holdings. I don't think you've had a look at Sebastian Holdings, yes, but it was referred to by my learned friend yesterday afternoon. I thought I'd just quickly take you to that. And the main point I'm going to make is that the principles set out in Sebastian Holdings apply in a very specific context that are not relevant to our case. Now, you find Sebastian Holdings, I think it is tab 8, the authorities bundle. And it's a rather complicated set of background facts, and I'll try and cut it down for you, but we can take it up from the head note on the first page. So it starts off with a master agreement for international swaps. You'll see that from the second paragraph. That had an exclusive jurisdiction clause, but it's not directly relevant to the subsequent dispute. What is relevant is the next set of agreements, and referred to in the next paragraph, the FX Prime Brokerage Agreement, which addressed foreign exchange and related trading. Now that contained a New York court jurisdiction clause, and that is the agreement under which Sebastian Holdings commenced New York proceedings. But then the parties also entered into an FX agent master agreement, which were used for offsetting transactions and was subject to a non-exclusive English jurisdiction clause. And then I think the only other relevant agreement is in the penultimate paragraph, the one beginning in January 2008. Towards the bottom of that, you'll see there's a reference to a master netting agreement, which was also subject to English court's jurisdiction. So you'll see at the very bottom, Sebastian Holdings bring their claim in New York under the Prime Brokerage Agreement, and the bank brings claims under the Agent Master Agreement and the Master Netting Agreement, which confers jurisdiction on the English courts. And in relation to those English claims, Sebastian Holdings raises defences based on fraudulent misrepresentation, breach of fiduciary duty, and the like, which it says has its origins in the earlier agreement that is the source of the New York proceedings. So, in essence, its argument was that the nature of the defence served to change the gravity of the dispute in the English proceedings from the two English law contracts to the New York contracts. And then, if I can ask your lordships, that's the background. I can ask your lordships to look at paragraph 57.
57.
57, yes, my lord. What the court is addressing here are how the various jurisdiction clauses in these agreements are to be interpreted. And you'll see there towards the top of 57, at the end of the first part of it, it says there are three factors which can objectively be seen as important when considering the construction of these clauses. Makes the point in subparagraph 1 that the clauses in all the agreements where Sebastian undertook direct financial obligations to the bank contain clauses which give the bank the right to bring proceedings against Sebastian in a named forum, in most cases London, or alternatively with the right to bring a claim in other fora where jurisdiction might be obtained. And then subparagraph 2, about five lines down, the obligations in the FX dealings incurred by Sebastian to the bank were under the offsetting transactions to be made under the FX agent master agreements. These were expressly governed by English law with its English jurisdiction clause. That's the second significant factor. And then the third significant factor, subparagraph 3, the agreements were entered into over a 2-year period. This is not a case of financial transactions closely related in time, such as where conflicting clauses might be found within agreements contained in the transaction Bible or the like. And then the court goes on to say, against that background, it is in my view, this is Thomas L.J., impossible to see how it can be said that the bank and Sebastian were to be taken to have agreed that the bank would analyse its claim and ascertain under which agreements the cause of action, cause or origins of the debts arose before issuing proceedings. And then if we could look quickly at 61 on the next page. Makes the point here that I turn next to the analysis premised on the parties having agreed that they would allocate jurisdiction to the contract which was the centre of the gravity of the dispute. So this was the defendant's argument, defendant's position. This is a different analysis as it focuses not on the underlying nature of the bank's claim, not which contract the claim was brought under, but on the dispute between the parties. It involves the acceptance that although the bank was ordinarily entitled to claim under the agreements under which the debt arose, and to rely on the jurisdiction clauses in those agreements, the parties intended that there would be circumstances where the bank did not have that right on the true construction of the series of agreements. 62, I cannot see how rational businessmen would have agreed this in the face of clear language of the agreements. So that is the background of the analysis in Sebastian Holdings. And we say that is very, very different to our case because the purpose of the anti-suit injunction that we seek is to ensure that a dispute that plainly does arise under the facilities agreement as to the occurrence of an event of default, no dispute about that, that is determined by the dispute resolution clause contained in that agreement. In other words, Fashion House's position is analogous to that of the bank in Sebastian Holdings, whose claim was also brought under an agreement that conferred jurisdiction on the English court. So the Sebastian Holdings approach and analysis is not on point. We're not saying that the gravity of the dispute in relation to the event of default takes the dispute outside its natural jurisdiction clause. We're doing the opposite. We're trying to enforce that natural jurisdiction clause. Analogous to this was the argument made by my learned friend yesterday that the effect of our case would be that the jurisdiction of the Moscow courts could be affected after proceedings had begun as a result of a defence that was raised by FHM. But that's wrong. Our case is that UniCredit is not entitled to commence proceedings before obtaining clarification that an event of default has occurred. And that simply requires them, in the absence of an agreement, to obtain an award before proceeding to the Moscow courts for enforcement. Lord, next I just want to deal quickly with Ms. Tresova's evidence, because we say that her evidence absolutely did not engage in the meaning of arbitration court and assert that it meant arbitration tribunal. Now, if you could just look at Ms. Tresova's first witness statement, please. Lord, in my copy, I hope it's the same as yours. It's section B, tab 3.
239.
239, we are aligned, I'm relieved to say. My Lord, there are two paragraphs that we need to look at. The first is the one I think you were taken to yesterday about my learned friend, which is 26. On page, I hope it's the right one, 246. And you'll see that Mr. Tresova says there, I note that pursuant to subclause 9.1.5, AO was not obliged before exercising its right to levy execution in a judicial procedure to take any action, just quotes that clause, take any action or obtain a decision of any court, arbitration court, or state authority against the mortgagor. In other words, the mortgage agreement expressly allowed AO to proceed straight to seeking to levy execution in the Russian courts. It did not require AO UniCredit to commence any other proceedings. There is no engagement there and no focus there on the meaning of arbitration court and the fact that it means, in her view, arbitration tribunal. She doesn't engage in that. Her conclusion in the second sentence of this paragraph is based on a structural broad analysis of the effect of clause 9.1.5a. And then the point is addressed again in paragraph 36, page 251. And you can see that more clearly to be Mr. Rosova's approach from paragraph 36, because in paragraph 36, what Ms. Rosova does is she lists, or she summarizes, I should say, four specific subparagraphs: 9.1.1, 9.1.3, 9.1.5, then over the page D, 21.1. Summarizes those, and then this is her analysis. Therefore, 37, therefore, under the mortgage agreement, AO was entitled to proceed to levy execution in the mortgage property without first obtaining a decision from the arbitral tribunal. Again, all that she's doing there is providing her view of the structural effect of those clauses in respect of a need to obtain any other decision, including from an arbitral tribunal. She does not focus on even on 9.1.5a broadly, let alone on the phrase arbitral tribunal, let alone say that that phrase, the arbitration court, let alone say that that phrase means arbitration tribunal.
Why is, just explain to me, because I'm a bit confused, why is this relevant?
This is relevant to the Latin Marshall.
What this means, surely, is a question of interpretation of the agreement.
Yes.
And what a witness says about it is barely relevant, if relevant at all. It's for the court to decide what it means.
So the relevance is as follows, my lord. Our case, and this is in the context of the Latin Marshall application, our case is that it was not clear to us until the hearing before Mr. Justice Henshaw that the respondents, UniCredit, were arguing that the word arbitration court in clause 9.1.5a means arbitration tribunals. Their response to that is, yes, it was clear. Look at what Rosova says in 26. That's the relevance.
And what is the relevance of the fresh material you wish to adduce if we are interpreting an English language agreement?
So here we come to the next point, which is, are you interpreting an English language contract, or are you interpreting a contract translated into English from Russian? So this is the question of which contract takes priority.
Do we know that it was translated from Russian into English? Where's the evidence of that?
Well, so you have...
All we know is that it was executed in both Russian and English.
Right. So that then leaves the court with this issue to consider: which version takes priority? And our case is that the Russian version takes priority for the following reasons. Firstly, this is a Russian law agreement. Secondly, it relates to assets in Russia. Thirdly, it is an agreement that is to be enforced by the Russian courts, by a judge who reads in Russian and probably doesn't read or speak English. Fourth, arbitration court as a phrase makes no sense in the English language or in the English legal context. It's not a recognized legal term in English. By contrast, it is a recognized term in the Russian language and in the Russian legal context when converted into English as a reference to the Russian state arbitrage court. And that itself, we say, is a further indication that the phrase was transposed from the Russian version of the mortgage agreement, which is a further indication that the Russian language itself prevails. So those are our reasons, my lord, why you should be taking arbitration court as being a phrase that has been transposed from the Russian version and that the Russian version should prevail. Let me just identify another reason why the Russian version should prevail, which is, if I could ask you to take up the supplementary bundle and look at the mortgage agreement version in that bundle.
Sorry, where are we? Supplemental bundle.
The page, I hope it's right, is 123. We're going to the mortgage agreement here. I just want to draw your lordship's attention to the following clause, 22. Yes, 22.1, page 163. So your lordship have that? 163. So you'll see there it says this agreement is made in 3 counterparts, 1 counterpart for each party and 1 for the registration authority. That is the Russian registration authority.
I'm sorry, I've got the wrong reference. What page are you on?
163.
Thank you.
So a copy of this agreement was to be provided specifically under the terms of the mortgage agreement to the Russian registry authority. It is entirely fanciful, therefore, to imagine it was going to be provided, or the intention of the parties was that the counterpart to be provided to that authority will be in anything other than Russian. So we say that is another very clear indication from the terms of the mortgage agreement that the Russian version was to prevail.
Well, don't the very next words say otherwise?
Each of which shall be.
Counterparts shall have equal legal effect.
I'm sorry.
Such counterparts shall have equal legal effect, if I'm looking at the right clause.
Yes, but this is talking about the 3 counterparts. So what this is talking about is that the agreement is going to be signed 3 times.
I see.
Both the English version and the Russian version, presumably.
Well,
This will be in both versions. So presumably what this is talking about is, as one often gets, you don't necessarily get both signatures on the same document. But so the English version is going to be registered with the registration authority as well as the Russian.
Well, what 22.1 does not do is to identify or to address a language point. In my submission, what it does is simply to say that this agreement, for the very reasons your lordship says, this agreement is going to be executed 3 times by the parties, and then because each party is going to get a copy, and then there needs to be another copy sent to the registration authority. In my submission, it doesn't engage in whether or not it's going to be Russian or English. What we take from this, however, is that the specific reference to one of the executed copies being sent to the registration authority is a firm indication that the parties were dealing with the Russian version.
No, because this agreement provides that a counterpart of this English agreement is to be sent to the registration authority, doesn't it?
There's no reference to English agreement.
We're looking at this agreement. We're looking at an agreement which is in English and has been signed. Yes, page 163. This is part of an English language agreement which has been signed.
But
and it says a counterpart of this agreement will be for the registration authority.
So
that must mean this English language agreement.
the agreement was signed in both the Russian and English.
Yes, we know. But that's not the point that's being put to you. The point that's being put to you is that clause 22 requires the agreement. In the case of the English agreement, the agreement in English, and in the case of the Russian agreement, the agreement in Russian, to be deposited with the registration authority.
Yes.
That's the point that's being put to you.
Yes, I understand. So what we know is that at the very least there is a Russian version that also says the same thing, and which requires that version to be sent to the registration authority. And we simply say that if one has to choose between the two, the fact that the registration authority is involved is a further indication that the Russian version, if there is to be a choice between the two, the Russian version prevails. Lord, the next point I want to deal with.
Can I just ask you this? We were moving off the Ladden-Marshall point. You tried to raise this before the judge, and as a matter of case management, he said it was unfair.
Yes.
What do you say about that?
So the reason why he said it was unfair was because the parties had agreed in preparing the bundles for the hearing below, and in order to manage the number of documents and pages, to remove the Russian version. Our agreement to that was before we had any inkling that that UniCredit was placing, was arguing that.
I know.
Yes.
That's what you say, but the judge decided on case management discretionary grounds not to permit you to run the argument you now wish to introduce in accordance with Ladden-Marshall.
Yes.
So do you not have to overcome his case management ruling that it wasn't fair for you to raise the argument?
Yes, and we say that ruling was itself, with respect to the judge, fundamentally unfair because it ignored the point that the timing at which the parties decided that the Russian version should not go in was at a point when it was not clear to Fashion House that UniCredit was making this argument about the meaning of arbitration court. The facts did not justify, plainly we say, did not justify the conclusion of Mr. Justice Henshaw that we should not be entitled to rely on the point for that purpose or for that reason. That's the way we put it.
I don't want to interrupt, but the judge's decision is at 59, and he did accept the point made by reference to Ms. Trezova's evidence. It wasn't simply the point about the agreement for the English version to go in.
I accept that.
Yeah, right.
Lord, those are the reply points I was going to make in relation to ground one. I just want to say one thing in relation to ground two, if I may. And that this was the argument as we understood that the court should take a different approach to jurisdiction given the fact that this was a negative declaration that we were seeking. The effect of the antecedent injunction we're seeking is a negative declaration. But we respectfully submit that that is not a realistic analysis of the context in which we make this claim. If the anti-suit injunction is granted, that would mean that AO cannot continue or commence enforcement proceedings in Moscow without first pursuing a VIAC arbitration and obtaining a declaration of an event of default. That is what AO, we submit, would in fact do. That is the commercial reality of what would occur if an injunction is granted, because the alternative would be for AO to abandon, AO and SBA, to abandon their enforcement rights, which they have demonstrated they are intent on pursuing. That is the commercial reality. Therefore, in a realistic and commercial context, this ASI application would in fact impact the validation of English law rights by requiring that they be addressed only in a VIAC arbitration. So this is not a Kamenigorsk case. Your lordships will remember that in Kamenigorsk, not only was there no arbitration on foot, but there was no prospect of an arbitration. Neither party had indicated that, and the circumstances didn't indicate that there was going to be an arbitration on the horizon or in the near future. That is not the case here when one looks at the consequence of what was going to happen if an injunction is granted. So we say this is simply an issue of timing, and that therefore the negative declaration characterization of our claim is not apt. It does not reflect the true situation. And as far as ground 3 is concerned, I just want to say a few words about discretion and limitation, which is the last point I think my learned friend raised. The context in which UniCredit raises the point that even if you have jurisdiction, you shouldn't exercise your discretion to grant the injunction is as follows. The Moscow proceedings will have been found to have been a breach of the arbitration agreement. The court will have found that it has jurisdiction to grant an injunction restraining that breach. And in that scenario, it is said to your lordships that the court should nevertheless exercise its discretion not to do so because UniCredit has chosen to leave until the end of the 3-year limitation period the step of pursuing what it says are its enforcement rights in Moscow. So in other words, it is said that the discretion should be exercised in UniCredit's favor to prevent it from incurring the prejudice brought about in the form of a statute bar to proceedings it was not entitled to bring in the first place and arising as a result of its own delay. And we say that would be a wholly inappropriate way of exercising a discretion. It would achieve an unfair result, not a fair result. My learned friend also referred to issues of comity in how you exercise your discretion. But the case law is clear on it that comity is only relevant in an anti-suit injunction context when the court is dealing with an application made on vexatious and oppressive grounds. It's a long-established principle that comity is not relevant where one is considering an anti-suit injunction to restrain a breach of an arbitration agreement. And the next point on delay is a completely new one. It has never been suggested below, and it wasn't suggested in the skeleton argument, that your lordship should exercise your discretion not to not grant an anti-suit injunction because FHM has delayed in bringing these proceedings. And all of the arguments that were raised this morning about the timing and what has been going on last year are completely new points. Completely new points. They are factual points. They are points that we were entitled to know about and respond to factually in evidence to explain why it is that we've taken the steps that we did when we did. And we have not had that opportunity because this is the first time the argument's been made. So I'd ask your lordship to give that argument short shrift. And I think, therefore, the last point I wish to make yes, I'm asked to clarify the point that FHM will not be appealing the Russian judgment if the anti-suit injunction is issued. I think that's...
Sorry, you said that FHM will not be appealing?
Will not be appealing the Russian judgment if an anti-suit injunction is granted, is what I'm instructed to inform your lordship.
Is that regardless of what AO does?
That's what my instructions are. Yes, if an anti-suit injunction is granted.
Even if it's not obeyed by AOs, I think the point.
I'm sorry, Lord.
Even if it is not obeyed by AO, so that AO, there is an anti-suit injunction, but nevertheless AO appeal. The instructions are in those circumstances FHM will not appeal. So I think that's what
I don't...
you're seeking to clarify.
Yes, to be fair, I think I'm passing up my instructions.
Do you want to just check whether those are your instructions?
Yes, but I think my instructions are coming through, not just from my instructing solicitors, but via electronically, should I
The
say.
instructing solicitor wants to speak to you.
Yes. Yes.
I thought so this way.
If they disobey, of course, if they disobey the order, FHM will, of course, exercise the rights that are available to it in relation to that disobedience. If that means-
That doesn't answer the question. Are you saying that if an anti-suit injunction is granted, FHM will not appeal? Or are you saying if AO does not appeal, FHM will not appeal?
It's the first.
Only the first. All right, that's clear. Thank you.
Lord, the last point I want to make is clarification about how our case has been put against SBA. Our case is not that SBA has induced a breach of contract. Let me be very clear about this. Our case is that SBA is in breach of contract. The first basis upon which we say it's in breach of contract, it's a point I made yesterday, that AO is acting in part and in significant part in the Moscow proceedings as agent for SPA. In that capacity, if the Moscow proceedings are a breach of the arbitration agreement, they are de facto a breach by SPA as well as AO. We also say, even if that wasn't the case, given that SPA is a party to the arbitration agreement, the terms of the arbitration agreement are, we say, clear. If the Moscow proceedings are a breach of the arbitration agreement and SPA has brought it about, has instructed AO to do so, that is a breach by SPA. And that is how the position was understood by Mr. Justice Henschel. Because the basis on which he rejected the necessary or proper party case, as an example, as an example, was that there was no arguable case of breach of contract by SPA. So he knew perfectly well how we were putting our case. That it was breach against SPA, it was breach against AO. So any suggestion that our case has not been put in that way, or not been put clearly enough, or not understood by UniCredit as being put in that way, I'm afraid is simply wrong. I'll just check with my instructing solicitors for any other points. Thank you. Yes, just to clarify, my lord, my instructions are that if FHM disobeys the order, if AO disobeys the order or SPA disobeys the order, FHM would keep its options open in relation to an appeal. Right. Lord, unless there are any other points I can help you with, those are my submissions in reply.
Thank you very much,
Thank
Mr.
you.
Cruz. Well, in view of recent developments in Russia, the immediate urgency seems to have gone away. So I'm assuming you don't require an answer immediately. We will, in those circumstances, reserve our judgment. We will, of course, endeavour to get you the answer as soon as we can. You will get a draft judgment in electronic form. It comes under a strict embargo, which means what it says, so it can only be shared with those on the distribution list, which has been given to the court. That will be your opportunity to correct our English, but not to raise new arguments and not to quarrel with our reasoning. We would hope that in the light of the draft judgments, you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short written submissions, and we will make the form of order that we consider to be appropriate. The hand done will be again electronic, by release to the parties and to the National Archives. Thank you all very much.
Thank you.
Private deal.